Chief Justice, and may it please the court, my name is Omar Perez, and I represent the respondent, Final Destination Inc. in this matter. Final Destination Inc. respectfully asks this court to affirm the lower court's decision and to find that 1. Final Destination Inc.'s speech is protected under the First Amendment of the United States Constitution, and that 2. Nova Statute 900.314 is unconstitutional because it does not pass strict scrutiny. To my first point, Final Destination speech, specifically the intentional advising, encouraging, and assisting of Amelia Jones's suicide, is protected under the First Amendment. The First Amendment states that Congress shall make no law abridging the freedom of speech.
But doesn't the government have a vested interest in protecting life over speech?
Yes, Your Honor, the government does have that interest. However, in a content-based restriction such as this one, the government must prove that the statute passes strict scrutiny, which it does not in this case.
Does the statute have to pass strict scrutiny even if we're balancing a life over speech context?
Yes, Your Honor. This content-based restriction must pass strict scrutiny because it is a long-established principle that the people have a bigger interest in being able to discuss ideas that the government may not find popular than the government does in restricting that speech. This court held in Police Department of Chicago versus Mosley in 1972 that government may not restrict speech based on its ideas, its subject matter, or its content. That is precisely what this statute does. It restricts speech that relates to suicide. The suicide is the subject matter which the government is trying to restrict.
But haven't we in the past upheld restriction of speech when there is a life balancing test? For example, people aren't allowed to shout fire in a crowded theater, correct?
Yes, Your Honor, that is one of the exceptions to First Amendment protection. However, none of the exceptions apply in this case. The exceptions that the state brought up in its argument under Gibney and Brandenburg both hinge on the same analysis, and that is whether or not there is lawless action being taken place here. In the state of Nova, the act of committing suicide in and of itself is not illegal. Therefore, neither of those exceptions will apply in this case. To my second point, Nova Statute 900.314 does not pass strict scrutiny, and that is because the government has failed to prove there is a compelling state interest and that the statute is narrowly tailored to achieving that state interest. This court held in Brown versus Entertainment Merchants Association in 2011 that in order to pass strict scrutiny, a content-based restriction such as this one, the government must prove there is a compelling state interest or an actual problem. This court held that is a very high standard that must be achieved. The fact that the government offers statistics showing that people have committed suicide here is not enough. Those statistics do not have any showing of how many of those people used Final Destination Inc. or similar entities. Because of that, there is no direct causal relationship between those statistics and the harm that the government claims is being taken place here. And because of that, the government has failed to prove there is a compelling state interest.
Well, but I think the government's compelling state interest is life itself, correct?
Yes, Your Honor. However, this court did hold in Brown that there must be a showing that there is a direct causal relationship. In that case, this court held that had the scrutiny level been intermediate, some lower level of showing would need to be shown. However, with strict scrutiny, in this case, there must be a direct causal relationship between those numbers and that harm. In this case, the state has failed to do so. Additionally, the government has failed to show that this statute is narrowly tailored to achieving that interest. This statute has the effect of restricting even general discussions on the issue of suicide. That is because the words used in the statute are not defined, and because of that, the people do not know what they can or cannot say, or what they can do or not do. The state argues that the words used in the statute should be defined by their ordinary meaning in the dictionary.
Isn't that how most legislative statutes are defined?
Yes, Your Honor. However, in this case, the meaning of the words that are given from the dictionary still do not help us understand what can or cannot be done. The definition of assist in the New Shorter Oxford English Dictionary is to help. It doesn't say physically, emotionally, mentally. There is nothing beyond the word help. That's simply not enough to put people on notice as to what they can or they cannot do. Additionally, the word advise just means to inform. The word encourage is to inspire with courage, spirit, or hope. Again, none of these words require a direct showing that what is happening is that Final Destination is causing this person to commit suicide. Now, even if this statute was severed, as the state argues it should be, under 760.140, none of these words will help us understand what can or cannot be done. Even if we chose just the word assist, again, to help does not put people on notice as to what they can or what they cannot do. The statute is simply not narrowly tailored.
Well, isn't your client counseling people on how to commit suicide?
Yes, Your Honor.
Wouldn't that fit into several prongs of the statute? Several of the definitions?
Your Honor, I cannot tell you because the statute is not specific enough. Again, to help. I cannot tell you what the word to help means by itself. It's not enough of a standard, there's not enough guidance to people as to what they can or cannot do. And because of that, this statute is having a chilling effect on the freedom of speech. It is not allowing people to discuss suicide, whether to encourage it or to not encourage it, because you simply don't know what you can or you cannot do.
What about the state's interest to protect vulnerable populations?
Yes, Your Honor, that is of course a interest that the government should have. However, in this case, when you have a content-based restriction, we have the strict scrutiny test for a reason. Your Honor, I see my time has elapsed. May I briefly conclude?
Yes, please finish responding and then conclude.
Yes, Your Honor. The strict scrutiny test is there for a reason, and that is because this country values the freedom of speech and does not want the government infringing on that right. And because of that, this test must be passed in order to have a content-based restriction. The government has failed to do that here. And because of that, we ask you to affirm the lower court's decision and to find in our favor. Thank you.
Thank you.